All right, who wants to lead the charge? Judge Thomason, you want to start?
Well, I'd be happy to. I want to lay out, if I might, how I see it. I'm going to withhold a vote at this point in time, but that's why I wanted a few minutes to make sure I had this together. So let me just run through this, and then we can go from there. Because the city charter basically says no council members to give orders. The code says orders, explicit direction, or demands, and of course you can make those to the charter members, but not the subordinate staff. Sonia Andrews said today that the direction was given by Councilman Graham to her in her office. I was surprised to hear that, but that's what she said very clearly, and not in Ms. Zoe's office. Councilman Graham, though, has said, and I looked back at his prior statements and what he said today very clearly, that he gave no direction to anybody. Anybody. Now, we've heard testimony that Mr. Graham may have said something like take it out or move it out. That direction, if those words were said in Ms. Zoe's office, that was not given to Ms. Andrews by her testimony. I respectfully disagree with Mr. Cassidy that her mere presence is an automatic pre-pass. I don't think that's workable. What if the charter member's not paying attention? What if the charter member's at the other end of the table and doing something else? I don't believe that her presence means there's no violation. In fact, Ms. Zoe said, I don't think she said it today, but she said in her interview that after she was given this direction by Councilman Graham, that she looked over at Ms. Andrews and Ms. Andrews didn't correct anything. I think the question is that we have to decide was an order or a direction given, and to who? Now, is a request an order? I don't think we should get into the semantics of that. However, I think in this context, it is. When somebody in a position of power and authority makes a request, sometimes they're being polite. I know, and I suspect all of us sat on the bench. I made requests. I asked lawyers to do things in front of me, and I may have been polite. Please don't do that. Please don't interrupt. I'm going to make this request of you, but that was an order. But I don't think we should get into those semantics. I take the testimony that Ms. Zoe and Ms. Johnson both believe that they were given a direction, and the emails confirm that. In fact, the email that was originally sent out by Ms. Zoe refers to requested, but then Ms. Johnson sent a follow-up email, because I thought, when I read that email, I thought she was saying, I don't think she said it strongly enough. She said, I just want to clarify that the direction is to pause any work on the project. Now, Mr. Graham says nothing was said at all, that it was pleasantries. He didn't make a request. He didn't make a demand. He didn't do anything, according to him. And Ms. Zoe and Ms. Johnson certainly disagree, at least with that. We can get into the semantics of exactly what they said was said, but the testimony of Ms. Zoe and Ms. Johnson on the one hand and Mr. Councilman Graham on the other are irreconcilable to me. I don't see any reason for Ms. Zoe or Ms. Johnson to lie. They believe they were given a direction, and it's reflected in their emails. And action was actually taken on that direction, and the fact that it was later rescinded, I don't think is relevant in a ethics situation. Like I said, I'm not making my vote yet. I think that's the way we tee it up and what we have to decide. I certainly disagree with Mr. Lasota that we have nothing. We have something here. I think it's a serious matter. I certainly take it serious. I know that the other members of this panel do. And I think Mr. Lasota, though, maybe I think he's probably correct that the spirit maybe of the code wasn't violated because there wasn't really an attempt to go around somebody, but the letter of the two provisions may have been violated. So thank you for letting me just, Judge Fleischman, tee it up. That's the way I see it. Again, without my vote yet, because I think it's I think it's a tough call.
Ken, what do you think?
Yeah, I think it's a tough call also. Excuse me, I disagree with Mr. Lasota. I thought the amicus brief was very helpful. It solidified in my mind that an ethics violation is a strict liability offense. Intention is not a defense. And maybe somewhat impactful, but I was impressed with the idea that you can have good intentions and still violate the ethics code. I was also very struck by Ms. Andrews' very clear statement that there was no direction given in the meeting with Ms. Johnson and Ms. Joe. And that was new, very emphatic, and that so we certainly have a conflict of testimony between the four people. I can appreciate that the two staff members overreacted to what they were told or understood, and maybe that's why it came up with the wording they did in the email and their discussion testimony. That's my comments.
Hey, Jim, can I thought Ms. Andrews said that she was the one, she introduced Graham and then she directed Zhao and Johnson to move the project out. I
Okay,
thought that
yes. Yes, you're right.
and that was at the meeting that Graham was at in that office.
Yes,
She was the one, and when you look at her original statement, I mean, it's skirting it a little. It's like, well, when she says, "I can't remember precisely what Councilman Graham stated, but I'm not accustomed to receiving orders for him," which sort of begs the question. It sounds like in her original declaration, she said that he did say things. And let me ask the two of you this. Let's say Ms. Andrews says, "Hey, let's go down and talk to these guys. They're the ones that know the answer to this stuff." They walk in, they introduce each other, and Mr. Graham says, "Hey, I don't like this 68 thing, straight thing. I want to try and get it out of the budget. I need some information for that." Would either of you consider that to be a violation of this code? I mean, to me, it seems like that's what a good elected official is trying to do, is get information.
Yeah,
I agree.
I agree.
That's not a violation the way you phrased it. I agree.
Yeah, I agree.
Turns me as Mr. Graham insisting that he never did that. He just sat there silently, other than, "Hey, how are you? Have a good weekend." I mean, that's still, it just doesn't seem realistic that he wouldn't just say, this here's why, or at least echo what Ms. Andrews is saying. Yeah, I don't, I want to put the kibosh on 68th Street. I need this information. Whether he was the one that said to move it out or not move it out, I'm not sure. And there's a dispute there. To me, the amicus brief is useful because it shows the danger that the statute is designed to prevent that clearly did not happen here. And what I mean by that is, for example, if you look at attachment D on this amicus brief for Mr. Duggan, he talks about somebody who was, if you don't quash the warrant, an elected official, if you don't quash the warrant, you're going to get fired, or threats
right.
to. There's none of that, and there's nothing here in that case. And in the amicus brief, they say at page 2, wordsmithing defenses should not be allowed. I agree. Notions that a lower city staff member would not be intimidated by a council member statement of preference should be dismissed. At the lower level of city staff, a council member's statement of preference is perceived to be the same thing as an edict. Maybe so, but where is the undue influence? Because the evidence here is these guys have their meeting at noon. A couple, 3 hours later, Ms. Zhao, who's supposedly so overcome and her will has been overcome by the demands of the elected official, is doing exactly what she should have done. Sending an email to her superior saying, "Hey, this request has been made. What do you want to do?" And so the thing I'm having problems with, I will tell you, is I agree with the two of you. Why would these two employees say what they said if something wasn't said? And that something may be a technical violation, but it certainly isn't something that would cause the concern that this amicus brief is dealing with. We're not dealing with the cases that they're talking about, I don't think.
But I do think that the two staff people, understood it was Mr. Graham's position, and that was the motivation for, under his point of view, Miss Andrews telling them to take it out or move it out. And so they would impute that to Mr. Graham, even though he may not have said it.
No.
And I think, and I alluded to this before, but I think the fact that this ended up being no harm, no foul, and you're right, that this is not the parade of horrible situation, but at the same time, I think one could argue that you need to strictly enforce these provisions to avoid that in some other case. But I don't think the fact that it ended up being no harm, no foul, to me, isn't relevant when we're talking about ethics violation.
I agree with that, but isn't the reverse a concern, that if we say that Mr. Graham technically violated the statute, we're going to chill?
Could be.
I worry about that aspect of it as well.
You're right. It could be, but on the other hand, you could also say you need to be careful.
Mm-hmm. Yeah.
I don't. This is not easy. This is a tough one.
Yeah, it is. It is. Which is why we get paid the big bucks to try and make these decisions. So I guess we have to make a decision. I don't.
Well,
I mean, I think it's fair. Isn't it fair to say, based on the testimony we've heard, that these two employees unequivocally say that Mr. Graham was the one that said, "Move it out, take it out," or we disagree with that?
I think complete agreement. There's no complete agreement with that.
And okay, and then we cannot. So the fallback, or the, in trying to not rule against Mr. Graham, is they might have perceived that he was saying these things, even though it was Sonia that was saying, because he's the higher official in the room. I understand that aspect also, but they seem pretty clear. It wasn't Sonia that was talking at him.
They were clear. Yeah.
No. Yeah. I know. All right. So we call the question.
Well, what, Judge Fleischman, since you're our chair, we'll let you go first.
Okay. I knew that was happening. Well,
that's contrary to the usual rule, I thought.
Can you get me that rule, Jim? Because I needed it.
I think of the Supreme Court.
Look, I'm sure we've all spent a lot of time looking up at the ceiling at night, wondering what to do about this. I know I have, and I know both of you have as well. On the one hand, I'm loath to say that a council member who really, at the end of the day, was trying to do his job, violated this prohibition. But on the other hand, I don't see any basis for why these two employees, in fact, if anything, it would behoove them to support what Ms. Andrews said. They could have come in here today and say, "Hey, yeah, it was really Andrews. Miss Andrews was talking. I don't know. Mr. Graham might have said a couple of things, but it didn't amount to anything." But they didn't do that, and you have to judge the credibility. I think my conclusion is, reluctantly, that there was an unintended and ultimately completely irrelevant violation of this statute, and that if that's what we're called to do, is to determine the credibility of the witnesses and the evidence, and apply it to the statute, then I think that would be my conclusion. At the same time, I would have to say that I don't think Mr. Graham intentionally did anything wrong. I don't think he was trying to exert any undue influence on these employees. I mean, the charter officer is sitting right there. He's not sneaking into their office on a Friday afternoon and saying, "Hey, do this, take this out." And the point about the taking it out, I mean, that also doesn't make much sense, because he knows, even though it's a temporary budget and all, he knows it's ultimately going to be up to the council to decide what is or is not in. So That would be my vote. I would say reluctantly. I think they have sustained their burden of proof, but I think it was really a relatively unintentional and minor situation.
You want me to go next?
Yep.
A couple of thoughts. First of all, I do want to say Councilman Graham's a public servant, and I heard him say, he's got a full-time job, and I think he's to be commended for that. And I think sometimes we don't show enough gratitude to people that sacrifice their time for the better good. I have I just from hearing things in the amicus brief, I have some concerns about politics and how that might be influencing what's going on here. At the same time, I can't be concerned about that, and I can't be concerned about the political ramifications of our ruling. We have to do what we think is right and let the chips fall as they may. And I believe that I'm with Judge Fleischman. When I weigh the credibility of the witnesses and I look at the evidence in front of me, I think there was a technical violation. I agree that it ended up being harmless, but I think there was a technical violation because I believe that Ms. Zhao and Ms. Johnson had no reason to lie, and I found them credible. And so that's where I come down. I'm very reluctantly like Judge Fleischman is.
Judge Mangum?
I will be the dissent and minority position. I think given the strength of Mr. Graham's avowal and Ms. Andrews' statements and the somewhat ambiguous or the less than perfect recollection by the two employees, the evidence tilts in favor of Mr. Graham, and I don't think there was a violation, so I will dissent.
Frank, let me ask you something. Can I put together like a little memo of what our conclusions would be, and then send that out? Obviously, make sure that the panel agrees, and then send that out, or how should this be resolved?
Unfortunately, with the open meeting law, it becomes kind of difficult to do this because, doing direct interactions outside the public meeting is hard. So usually the way this ends up happening is the panel would assign the job of writing it to one of you, and then a way to get around having another meeting is you can send it out. If they want to raise objections, then we could set another brief meeting to talk about the specific wording. If they don't have any objections and they say, we're fine with it standing, then that can be registered as the final ruling. I know that this process is kind of a painful one for judges who are used to deliberating, as you say, in private, but because of the open meeting law constraints, there is some necessity to kind of do it publicly. So, one option you could do is, if you'd be interested, is actually to just
dictate it right now.
You could do it.
Yeah, can I do that?
Yes, you could take 20 minutes right now and come back and just show what it is that you're recommending, and have everybody just on the record say, yeah, that's it, and let's go with that. And that would be the cleanest way to do it.
Well, Tim, Thomason, let me ask you this. I would be happy to just conclude that based on what the two of us have said, that we believe there was a technical, unintentional violation of the ethics rule, and that given that situation, or given the unintentional nature of it, that I don't think anything should happen to anything with Councilman Graham. It should just be a lesson to be more careful in the future, and that's it.
I'm perfectly consistent with what you just said.
That's good summary.
All right, so I guess that's the conclusion. We don't have to take any more time to do it.
No,
mean,
that's right. I can write that. I have,
Okay.
obviously this is being taped, so I can write that into a written document that can be sent to the council.
Yeah. It's kind of, yeah. Okay. Well, then that's where we're at then. Guess we're done. Thank you all.
The only last
Oh,
thing I
yes.
need to have you do is that to avoid having to have another meeting to approve the minutes, if you could, an item on the agenda is number 4, further actions relevant to the finalization of this independent ethics review panel. What I will do is I will write up what Judge Fleischman has just said. I will distribute it. If there's an objection, or if individuals want to weigh into me on the wording and make tweaks, that's fine. But if there's a desire to make significant changes, we would have to have another meeting. But short of that, if you could authorize pursuant to number 4 that I would simply write up this ruling and deliver it to the council, and then also that the minutes of this meeting don't need to come back to the panel for approval at another meeting. That's the sort of thing that item 4 is intended to cover.
Thinking out loud, Judge Thomason and Mangum also, I think we should put something in there. I mean, I really don't want to chill a council member's, right to obtain information and stuff. Can we address that at all? Because I know that was the intent of Councilman Graham when he went down there. He wasn't trying to order these employees to knock out this budget. Any language we think we can put in regarding that? I did, yeah. Tim, I can't. Tim
maybe
Lasota, we can't hear you. Tim Lasota, you're on mute.
Didn't interrupt the deliberations. I'm just talking to my client.
Oh, I'm sorry. Okay. Sorry about that.
Are you thinking something like this order is not intended to in any way interfere with a council member's ability to obtain information from city staff?
That would be fine with me. Is that okay with you, Judge Mangum?
Yes, that's fine.
All right, let's add that in there, because I think that's important. Because I agree with Judge Thomason. It's an ethical problem. It's a strict liability issue, but I don't think anybody intended to do anything wrong. That's for sure.
Okay.
All right. Anything else, guys?
Thanks, everybody.
All right. Thank you all.
I'd like to know what Mr. Mangum's vote is. Is he dissenting, or is he?
He's dissenting.
I dissented. I think there is no violation based on the evidence.
He dissented. Yeah.
All righty.